An analysis of the above reproduced provisions shows that, in terms of Section 3, the state government can requisition any premises needed or likely to be needed for any public purpose. Section 6 provides for disposal of premises after the same are requisitioned under Section 3 within bracket 1. Under that section, the state government has been bestowed with the power to use or deal with the requisitioned premises for the specified public purpose. Section 11 within bracket 1 postulates payment of compensation for the requisitioned premises. The amount of compensation is required to be determined by either of the two modes prescribed therein. If the parties voluntarily enter into an agreement on the quantum of compensation, the amount is to be paid in accordance with such agreement. If there is a tenant in the requisitioned premises, then, in terms of Section 13, the collector is required to decide whether the agreement for payment of compensation shall be entered into with the tenant or with the immediate landlord of such tenant. In case the parties cannot agree on the quantum of compensation, the state government is required to appoint a district judge or an additional district judge as an arbitrator and notify the same in the official gazette. Rule 8 provides that where the amount of compensation payable under Section 11 cannot be fixed by agreement, any person interested can make an application to the collector for referring the case to arbitration. Thereupon, the collector is obliged to refer the case to the arbitrator and give an intimation to the person or persons interested and the state government. Where no such application is made within a reasonable time, the collector can suo motu refer the case to the arbitrator and give the required intimation. In terms of clause within bracket C of Section 11 within bracket 1, the state government is empowered to nominate a person having expert knowledge about the nature of the premises requisitioned to assist the arbitrator. In that event, a corresponding right is available to the person to be compensated to nominate an assessor. At the commencement of the proceedings before the arbitrator, the state government and the person entitled to receive compensation are required to state their respective opinions as to the fair amount of compensation. Thereafter, the arbitrator has to determine the amount of compensation keeping in view the matters enumerated in clauses A, B, and C of Section 12. Once the award is made and signed, the arbitrator has to inform the parties to the reference by sending a notice in writing and also send copies of the award to the collector and the person or persons interested. What is most significant to note is that neither at the stage of fixing the amount of compensation by agreement nor at the time of appointment of arbitrator the state government is required to consult any person including beneficiary of the requisition. The only person with whom the state government is required to negotiate the amount of compensation is the one whose premises are requisitioned.